Morning, my dear friends. Today's subject is legal rights. We will discuss what is legal rights, essential elements of legal rights, and different kinds of legal rights. Now we will see what is rights. There are two types of rights: one legal right and moral right. Legal rights are the interests which are protected by law. Moral rights are not protected by law. It is morality up to him. Man has several interests. All the interests are not protected by law. They receive no recognition from the law point of view. Violation of them is not at all wrong. So, rights, wrongs, or duties are either moral or legal. Moral interest is recognized and protected by rule of morality. Violation of moral right is moral wrong, but it is not enforceable in the court of law. What is moral duty? Respecting elders, giving all to the poor. These are all moral rights. If the children don't obey the parents, they cannot go to the court. But legal rights are recognized by law and it is enforceable. Legal rights has four different kinds: rights, liberties, powers, and immunities. So, rights and duties, correlatives. Liberties, no rights. Powers, liability, they are correlated. Immunities, disabilities. So, now we will discuss the 4 points. What is right and liberty? Right cannot exist without duty. But liberty of a person means he can do without legal interference by the others. Right is a wider sense. Now, right and power. Right and duty are correlatives. Power has no duty. Legal right is an interest recognized and protected by the law. Power means person's ability to do something. Correlative of right is duty. Correlative of power is liability. Now, right and immunity. Right is a wider sense, but immunity is not so wide. Right means other person ought to do on a person benefit. Immunity means law denies others a particular power over the person. Right is granted to every person. Immunity is granted to a special category of persons. For example, immunity to the parliament members. So, duty is correlative of right. Disability is correlative of immunity. So, definition of legal right. Legal right is an interest guaranteed by law. Party has a right when another has a duty. Right is a freedom allowed by law. Essential elements of legal rights. The legal right is always vested in a person who is the owner of the rights. The right avails against a person whom lies the correlative duty. It is obligation on the person bound in favor of the person entitled. The act or omission relates the thing over which the right is exercised. Every legal right has a title. That means certain facts or events vested in the owner. So, essentials of the right: person of inheritance. Legal right is vested in a person who is treated as owner of the right. He has the right to inherit to someone else. For example, owner of a property can bequeath it to unborn person. Unborn person has a legal right over the property. It is not a question whether unborn person born alive or not. Second, person of incidence. The legal right avails against a person against whom lies the correlative duty. For example, right to the parents toward children. Contents of the rights. The act or omission is obligatory on the person. He is bound to do the act in favor of the other person entitled. There is a contract between A and B. A has to supply goods to B and he has to receive 10,000 rupees. The right to receive the goods under contract is contents of rights. Title of rights. Every legal right has a title. Every legal right has a facts, events vested with the owner. Owner can transfer, create or extend these rights by way of assignment, gift, bequeath and prescription. Subject matter of right. The act or omission relates to the thing over which right is exercised. For example, right to property. Subject matter is property. Right to reputation. Subject matter is reputation. Classification of legal rights. Legal rights with material objects. Legal right with immaterial objects. Legal right over one's own person. Legal right of reputation. Legal right of services, legal right of personal life, legal right pertaining to other matters. Now, kinds of legal rights. Perfect rights and imperfect rights. What is perfect rights? It is not only recognized by law but also enforced by the law. I have taken 10,000 rupees loan from B. I have executed a promissory note. There is a perfect right in favor of the creditor. I have perfect duty to pay 10,000 to B. Perfect right in favor of creditor. Perfect duty in favor of debtor. This perfect right is recognized by law and enforceable by law. Imperfect right. What is imperfect right? It is a right recognized by law, but this right cannot be enforceable due to its defects. For example, I have taken 10,000 rupees from B during 2010. I have executed a promissory note on 2010. As per law, there is a limitation period. Within that period, creditor has to take action for recovery of money. We did not do it. So, it is imperfect right of the creditor. The limitation extinguished only the remedy, not the right. Infected, imperfect duty is duty of such a nature that it is not fit for enforcement. Imperfect rights are not recognized by law. Now, positive right and negative right. What is the positive right? Other person is subject to the duty to perform it. He is bound to do something. Positive right involves positive act. Other person must do it. Positive right corresponds to a positive duty. For example, payment of debt of 10,000 rupees taken by me from B. B has a positive right to receive 10,000 rupees. I have positive duty to pay rupees 10,000. Negative right. What is negative right? Person is bound to refrain from doing something or some act. It means he should not do something. Object to the negative right is not to harm others and to maintain status quo. Negative right correspondence, negative duty. Now, right in rem and right in person. Right in rem means right available to the person against the whole world. For example, I am a owner of a house. People of the whole world have a duty not to interfere with my possession. Nobody has the right to disturb my possession. For example, I have rupees 10,000 in my pocket. I can use my money as I wishes. The whole world has no right to interfere with my money. This right protects the interest against the world at large. It is called as right in rem. For example, patent rights or copyrights. All rights in rems are negative rights. So that means nobody should interfere with my possession. Right in person name. What is right in person name? This right is available only against a particular person, not against the whole world. For example, I have taken 10,000 rupees loan from B. Now B can demand money only from me, not from the whole world. I rented my house to A. A is a tenant. I have a right to receive rent from my tenant only. This right protects an interest solely against the specified person. All rights in personam are positive rights and easementary rights are right in personam. Now, proprietary rights and personal rights. Proprietary rights means rights over his assets and property. These rights have monetary significance. They are determinants or elements of wealth. For example, money, land, house, shares, and patents, goodwill, books, utensils, and debenture, etc. So, proprietary rights are alienable. You can give it to somebody else. Personal rights, it is relating to one person only, it is body. All family relations is rights. Family relation of wife and husband, it is personal right. Family relation of son and parent, personal rights. Personal liberty, reputation, freedom from bodily harm are personal rights. These are elements of man's welfare. Personal rights are not alienable. Principal rights and accessory rights. Principal right is independent of any other rights. Accessory right are ancillary to principal right. Principal rights, for example, having ownership of possession, title on the land, building. The owner of the building has the principal right in the building. Accessory rights, easementary rights are accessory rights. For example, right to way is accessory right. Primary rights and sanctioning rights. Primary rights are also called substantive rights. For example, I have a primary right not to be assaulted by anyone. Primary right is either a right in rem or a right in person. Sanctioning rights are called remedial rights. Sanctioning rights originate from the violation of primary rights. For example, I have a primary right not to be assaulted by anyone. Now, some person A has assaulted me. I can claim damages, claim of damages for breach of contract or breach of peace. This is so sanctioning right is always a right in possession. For example, A assaulted me. Not to be assaulted is a primary right. I have right to get compensation. It is sanctioning right. Legal rights and equitable rights. Legal right is recognized by the courts of the law. These are certain rights. For example, I registered a mortgage. It is a legal right. Equitable rights are recognized by the courts of chancery. These are uncertain rights. For example, mortgage of property by simply keeping the title deeds with the creditor. It is equitable mortgage. Mere deposit of title, mortgage created by written agreement. This distinction between legal and equitable right originates from the distinction between law and equity. Vested rights and contingent right. Vested rights are which are occurred out of the facts. Vested right is heritable. Vested right is not defeated by the death of the transferee before he obtains possession. The property possesses to his heirs. Transferee obtains the right absolutely. For example, A grants a piece of land to B in a simple will. It creates a vested rights of ownership. Contingent right. Contingent right is one which vests to a person only on the happening of a condition, only on happening of a certain event. Contingents become perfect only a certain condition is fulfilled mentioned in the deed. Contingent right is defeated by the death of the transferee before he obtains possession. Contingent right is not certain, hence it is not attachable. So transferee owns it merely conditionally. Now, right, public rights and private rights. Public rights, right vested with the state is called public rights. State enforces such rights on subjects in public interest. Private rights, it is concerned only with private individuals. Now we are talking about duty. Duty is opposite to right. What is duty? Duty is an act which one has to do, an act opposite of which is wrong. If I not do it, it is a wrong. When law recognizes an act as a duty, it commonly enforces to perform it. Duty is a type of obligation. People obey it with the deference, sympathy, fear, and reason. Now, the relationship between the right and duty. There are two theories. One, right and duty are correlatives. Another, right and duty are not correlatives. Right and duty are correlatives. What is that? Duty is owned by one person to another. Right in respect of which there is duty and violation of which is wrong. There can be no right without corresponding duty. For example, servant has a duty towards his master. It is the duty of the child to obey the parent. It is the duty of the citizen to obey the law of the country. We cannot have the rights without corresponding duties. Another is that right and duty are not correlatives. This is another theory. For example, if the state compels children to go to school, or if the state compels the children, prohibits the sale of certain drugs, if the state compels alcoholic drugs, there is no corresponding rights. So, this is another theory. This types of duty is divided into two categories. One, absolute duties and relative duties. What is absolute duty? Absolute duty means complete and unconditional duties. They don't have rights. They are only duties. Breach of which is called crime. Remedy is punishment. For example, duty owes to the state. Duty owed to the God. Duty towards animals. So in this, owed to the state, breach of which is called crime and remedy is punishment. Another is relative duties correspond to the right. As per this theory, right and duty are two sides of the same coin. Relative duties are owed to any person other than one who is imposing them. Breach of duty is civil injury, remedy is compensation. Example, duty towards God, not to commit suicide. These are all the relative duties. Thank you. The end.